गं गणपते नमो नमः शङ्करि तनया नमो नमः गं गणपते नमो नमः शङ्करि तनया नमो नमः गं गणचरणा अंगुशधर मंगलकर पंकज चरणा वारण अंकुशधर मंगलकर पंकज चरणा वारण सा सनि पग पनि ग परे गनि पगरे सरे ग सरे सा गरे सरे पगरे गनि पग प सरे ग पनि सरि गरि नि पग प सरि सरि नि पगरे गनि पनि नि प गरे सरे पग पनि पग प सनि पनि गरि सरि गं गणपते नमो नमः शङ्करि तनया नमो नमः गं गणपते नमो नमः पंकजासनादि वन्दित भक्तादि हरण मुदित पंकजासनादि वन्दित भक्तादि हरण मुदित कुङ्कुमाप गुण निधे हरि केश कुमारा कुङ्कुमाप गुण निधे हरि केश कुमारा मन्दार कुङ्कुमाप गुण निधे हरि केश कुमारा मन्दार सा सनि पग पनि ग परे गनि पगरे सरे ग सरे सा गरे सरे पगरे गनि पग प सरे ग पनि सरि गरि नि पग प सनि सरि नि पगरे गनि पनि नि प गरे सरे पग पनि पग प सनि पनि गरि सरि गं गणपते नमो नमः शङ्करि तनया नमो नमः गं गणपते नमो नमः.
A very good morning to all of you present here, dear teachers and dear students. Today we have with us one of the eminent judges and who was the former judge of the High Court of Karnataka. N Kumar is known to all of us. You being the younger generation may not be knowing. He served in the High Court of Karnataka between 2000 to 2016 as a judge. During the course of his office as a judge, he has delivered wonderful judgments, be it in the area of constitutional law, be it in the area of company law, be it in the area of family law, and in matters like arbitration and in regard to university disputes. That is where he excelled and he is known. And not only he is a wonderful judge, but he is a wonderful scholar as well. And when we speak about his scholarship, remember the authorities at the judiciary, having known him, he became the guiding spirit of the Judicial Academy of Karnataka. It was he who shaped the Judicial Academy in the state of Karnataka. And because of him today, the Judicial Academy is known, Judicial Academy of Karnataka is known throughout India to everyone. Not only in this area, but in the area of mediation and arbitration. He was the executive director of the International Council for Mediation and Arbitration. As the executive director, he has done wonderful work. I still remember when he was serving as the Vice Chancellor, he had conducted a conference in Belgaum. And at that time, he just asked me to come and speak. Well, these are a few instances. In addition to that, he was invited by the judiciary of the state of United States. And The very purpose of inviting him to the state of United States is to study the method of mediation in a few states like the state of California and the state of Washington. And this has given and inspired him a lot. And to a certain extent, by taking into consideration our circumstances and our laws, we are able to implement a few of them. In addition, he has rendered wonderful judgments in the area of IPR. He has been invited to international conferences on this subject, even abroad. And he is the most feared judge as well. Many of you may not be knowing. I do still remember one of the instances it is only for, not for public, for private. We had a registrar in the University of Bangalore, because I too was serving as a registrar. And there were certain allegations, and during the course of the argument, he was asking for some time. Honorable Justice said, if you are allowed to continue, tomorrow something else will disappear from the university. No time will be given to go out. This is the kind of thing, these are the type of judges we require to work, to see that the democracy and the principle of democracy works efficiently. Sir, we are honored to have you. And as soon as I requested him to speak on the new subject, because the law has just come, and it is just has come out and entered into the books of Gazette. So he said, I will come and speak to you. These are the promptness of people who, remember, cherish academy and academic matters with the students and share them throughout. On behalf of the CMR group of institutions and the Board of Management, I present a bouquet of flowers to the Honorable Sir.
It's my privilege to introduce our speaker for today. Honorable Mr. Justice N Kumar was born in Chikballapur in the year 1954 and completed his primary and secondary education in Bangalore. He graduated from Vijaya College, Bangalore and completed his LLB from Sri Jagadguru Renukacharya Law College, Bangalore. He pursued his Masters in Political Science from Karnataka University, Dharwad. Sir enrolled as an advocate in the year 1976 and joined the office of Sri L.S. Varadaraj Iyengar, a leading civil practitioner. In the year 1991, he began his law firm Kumar N Kumar and extensively practiced in matters that dealt with civil and constitutional law, company law, labor law, and various other legislations. He has also served as the legal advisor for several institutions. Sir's legal acumen, sincerity, and honesty elevated him from the bar to the bench as Judge, High Court of Karnataka in the year 2000. He served as the Executive Chairman of the International Center for Alternative Dispute Resolution, Bangalore, and involved in promoting arbitration, mediation, and conciliation as an alternative mode of resolution of disputes and thereby reducing the burden of courts. Sir retired as Judge, High Court of Karnataka on 26 June 2016. He is the President of Karnataka Judicial Academy. Sir's expertise in civil matters and constitutional law has brought in-path-breaking judgments and have great precedential value. We look forward to build new perspectives on the Mediation Act 2023 and its way forward and have a great learning experience today. I now invite Justice N Kumar Sir to address the gathering on the salient features of the Mediation Act 2023, way forward.
Good morning to all of you. I'm glad that the present generation is far quicker than our generation. Even before the act came into force, even before the presidential assent, professor called me and said I should deliver a lecture. So I said, let me look into the act. In my internet, I could not get the act at all, because it was not there. Then I said, send me a copy of the bill. By the time he sent me the bill, the presidential assent was given on 14th. It was published in the official gazette on 15th, and within 15 days, they are here to understand this enactment, which has become a part of the Indian law after Section 89 was introduced into the Civil Procedure Code. Now we have been talking about mediation in India for more than 2 decades. I was intimately connected with this mediation, and therefore I had to withdraw from this when I saw peculiar things are said about mediation. Now that I am before youngsters, let me tell you a few things about which you should be careful before we go into the act. Otherwise, again, as we have made many of the laws useless, this also will make useless. That is my apprehension. In the seminars, workshops, you will see lectures given by people. With great respect to them, I should say, without knowing what exactly the mediation is. I am sure you must have heard or you will hear. You will not. You will know also I will hear. That's why I am in advance. I am putting a caveat. That this mediation is not new to India. See, in Ramayana, we had Lord Hanuman went to Ravana. The mediation did not succeed, war ended. Then they will talk about Sri Krishna went to Pandavas, the Kauravas, to mediate. And therefore that was also, but both were not mediations. Let me tell you the reason why it is not mediation. Then they will say in the rural India or the old earlier days we had panchayats. 5 people used to sit and sort out their battle. No question of litigation. That panchayat system is not mediation. What Krishna did is not mediation. What Hanuman did is not mediation. The first thing you must bear in mind. In India, this concept of mediation is totally unknown. We have inherited the Anglo-Saxon jurisprudence. This concept of mediation is totally unknown in Anglo-Saxon jurisprudence. If you carefully look into the Anglo-Saxon jurisprudence, the only mode of deciding a dispute is by adjudication. There was no other alternatives. You must know England is a small country. It is smaller than Karnataka, population-wise and otherwise. There are no disputes, and that could be decided by way of adjudication. When we inherited in India, with this population, with this variety, it had its problem. There was a delay in disposal of cases, both criminal and civil cases. It's because of population. It is nothing to do with the system. Let me tell you today, being a part of the system for the last 50 years, the system which this country is following is the best in the world. The problem is, the persons who are running the system are not good. It is just like the latest car, BMW, given, but the fellow does not know how to drive it. Then why you are blaming the car? So our system is the best system in the world. The persons who are in charge of the system, who are running the system, lack experience, lack competence. That's where you count. Please know the system is good. If you are able to rise to the occasion and you are able to run the system, this is the best system. But nonetheless, this Anglo-Saxon jurisprudence was adopted by Americans also because they were the British colony. Say about 70, 80 years back. So they don't do what the Britishers do. Whatever, if the Britishers wear a black dress, they will wear a white dress. Whatever they say, they are just opposite. So when the Anglo-Saxon jurisprudence, even in America, resulted in delay in disposal of cases, then they thought of having alternatives. One such alternative, which is called as ADR today, is the mediation. Today, 90% of the litigation in America is decided by mediation. Arbitration is not successful there. Litigation is very costly. If anybody gets into litigation, in the end of the day, it will become a pauper. That is why mediation is accepted. The success of mediation in America is because of the cost factor involved in the litigation. Now, as you see the Civil Procedure Code, in 1976, the first amendment was effected. On what ground? The Civil Procedure Code is coming in the way of speedy disposal. Alright. the Parliament amended the CPC. The next amendment was in 1989 on the same ground. Again there is an amendment in 2002 and again there is an amendment in 2015. The Parliament, the politicians believed the legal luminaries of the country saying that CPC is coming to the way. If you ask me, if we had followed CPC in letter and spirit, there would not have been any delay. It is disregard of the CPC which is the root cause for delay in disposal of cases. Anyhow, now they have realized we can't trust these lawyers, trust these judges. This allegation is made by the highest judicial appointee, the Chief Justice. Then they try to get, they entrusted this matter to an outside agency to find out what is the problem in the India for delaying disposal of cases. They said only two things. One, there is no early judicial intervention in our system. Secondly, the litigation is controlled by the client and not by the judge or the lawyer. That is the 100% truth. Therefore, government will not take any more these stories saying CPC is responsible, CRPC is responsible. No. So it is in this background, this concept of mediation as an alternative dispute resolution mechanism was brought into our law, Anglo-Saxon, in the year 1989 by introducing section 89 to the Civil Procedure Code. So it is American jurisprudence brought into Indian jurisprudence by way of section 89. Then in that famous Supreme Court case, that is Salient Advocates Association case, certain directions were issued. Jagannath Rao committee was constituted to frame mediation rules. Thereafter, the high courts were asked to either follow or modify and frame the rules. At that point of time, I was in the high court and I have framed the mediation rules for Karnataka. And that's how the mediation became a part of the Indian law. So throughout the state, throughout the country, every state has a mediation center controlled by the high court. But still we did not have law of mediation. And I said, this is the lectures we were hearing. Krishna's diplomacy, Hanuman's diplomacy, Panchayats, etc. I point out to you from the provisions of the law, probably now after 20 years of experience, there is some clarity, there is a purpose, and if you are able to follow this in letter and spirit, probably we may see some good results, and so that the burden on the regular courts is reduced. The adjudicatory process which is there in Anglo-Saxon jurisprudence is not bad. The problem was, I think by this time you have seen courts, you also have classes. Every person has a right. If it is wrong, he has a remedy. That's the basic. Therefore, he has to approach a court of law. So I applied this to be filed. Written statement is to be filed. Issues are framed. Both the parties adduce evidence, examination, cross-examination, arguments, then judgment. The process takes time. Nothing wrong with the system. The process takes time. Even here, let me tell you, the process, if it is not successful, it is not because of the law. It is because of the lawyers and judges who have no respect for this process. The law says that once the trial has commenced, it should be day to day. We have not seen it at all. Even in the Sessions case, we have not seen it. When I entered the profession in 76, if a suit is filed, minimum 2 years is the time which we used to take for filing a written statement. Then we had application calling for particulars, objections, hearing, order, a revision to the High Court, get the matter straight. This is supposed to be the test for a brilliant advocate. See that the matter doesn't move at all. They are proud. I will make this fellow come to court for 20 years. Why do you blame the law? The mentality of the lawyers. Similarly, the judges, they took their own time to decide small matters. Either they were not competent, they were not enthusiastic, and this is the result. Therefore, there was backlog of cases. It was stuck. So it is in this context when they were trying to find out an alternative remedy. This mediation, which is followed in America, which successfully, and that was brought in here. You must know what is mediation in America and what we are doing here. I had an occasion to go there at their cost for studying mediation. See, they were all, I asked them, why are you spending money on us? They spent money on us to see that we come back, we develop a mediation process here, and all this was behind a selfish motive of seeing the intellectual properties of those fellows are protected. In India, if a litigation starts, you are stuck for 20 years. Then by the time expires, if it is a patent, 20 years period is over before your litigation is decided. The whole object of bringing this mediation center through them, we did not bring it. They wanted to bring it here. They spent considerable money. And whenever we attend a conference in a 5-star hotel arranged by these fellows, our judges, including the chief justice, no member granted permission. So actually, please understand, that's why I said, you are the new India. You must understand this motive behind these international players. They spend money like anything, it is nothing when compared to intellectual property rights. In America, the mediation is successful. I don't know why it is not successful. This is the reason. Today, Professor was saying our youngsters also will be trained as mediators. It doesn't happen like that. In America, the mediation is successful. It is for this reason. It is called as a court-annexed mediation and private mediation. In a court-annexed mediation, when the case goes to the district court, if it is a fit case for mediation, he will allot it to a subordinate judge. He conducts this mediation proceedings. And after the mediation arrangement is arrived at, it will come before him, he will pass an order. That judge who conducts this mediation process will be there only for 3 years or 5 years. Once he becomes an expert, he resigns. Why? Private mediation is so famous, and even from any standards, the money they earn out of that is something which you can't believe. Secondly, in a private mediation, there were lawyers in our country also. That's why I said, sir, please. There were lawyers who are putting 20, 30 years of experience. They have made money. Afterwards, they realize he has money, he has everything, but nobody is respecting him. In our country also same thing. People have made money. How they have made money, they know it better than anybody else. But they are not respected. You are all youngsters, you don't understand this. After you make money, in the end of the day, if you are not respected, you will feel that the entire life is a waste. So when a lawyer reaches the stage, he wants respect. Therefore he says, I will do mediation. Because he doesn't need money, he has got money. He wants mediation. So what do? Alright, I do. And at the same time, if you do mediation, clients also will take advantage. What they do is, alright, I will give you time for 3 hours free. If you don't settle it within 3 hours, then the clock will start ticking. Per hour it is $100. So the clients who are afraid of paying money, they try to settle. Otherwise, per hour it is 100. And compared to our country, the reason why I am saying it is very difficult for us to succeed. When you become lawyers, you will see when a client comes here, when you start talking to him, he will start talking about his grandfather first, then his father, then himself. The next day he will come to this subject. How do you control it? Keep a clock. Tell him you can talk any much you want, per hour this is. Then you will finish it in 5 minutes. So that culture should develop with the Mediation Act to succeed. Therefore, mediation is very successful in America and we have brought it. 20 years are over. What is the success we have made? It's not very encouraging. Now we have said make it alone. We said there is no statutory backing like arbitration. So make it give a statutory backing. Therefore today we have this Mediation Act of 2020. So it has certain very good points if utilized by the litigants and the legal fraternity. It may be a solution to the problem with the country is facing. But let me tell you, all the litigation which is before the court doesn't need adjudication. But in the absence of an alternative dispute resolution mechanism, everything has to go through this adjudicatory process. Today, we have arbitration, mediation, conciliation, Lok Adalat, and judicial settlement. This is what 5 alternative dispute resolution mechanism brought into the Indian system by section 89 of the Civil Procedure Code. But let me tell you one aspect, whether it is adjudication, mediation, arbitration, anything else. What is the cause for a dispute? First, in all this you are trying to resolve a dispute. What is the cause for dispute? It may be greed and avarice. It may be ego and pride. It may be jealousy and intolerance. It is anger and hate. If this is the cause, tell me how does this lawyer do to solve the dispute? Therefore, everything need not be adjudicated upon. If you are able to control these aspects, then probably the resolution may be easier and satisfactory also. In an adjudicatory process, even after an elaborate trial, when the matter is decided, one person is agreed. So therefore you have an appeal. Therefore you have a second appeal. Then the Supreme Court, 40 years, 50 years. So it is in this background. Now we thought arbitration is the best. Arbitration is very successful. There is no doubt about it. But still the same problem. Maybe in the trial court it may take 10 years. Before the arbitrator it may take 2 years. The scope of attack under section 34 of the Arbitration Act is very much limited. Still there is a provision against which an appeal to the High Court, then an appeal to the Supreme Court. Again, it is an adjudicatory process. So as opposed to this adjudicatory process either in court or by arbitration, this mediation has an edge over all this provided the parties want a settlement. Otherwise there is nothing you can do, there is nothing this law can do. If parties wants a settlement, if they make up the I will not go to court, I will not waste my time in court, I will not waste my money in court, I want to go ahead, this is coming in the way. All you are all youngsters, when we come to litigation, a client will come and say, sir, I am depending on this litigation. Once it is over, I will start constructing a house. Once it is over, I will perform the daughter's marriage. It will never happen at home. This is the Indian psyche. See, the culture in America, England is totally different from our culture. It should apply to the Indian society. So therefore, mediation would be successful only if the parties want an amicable settlement at the earliest. They are innocent, ignorant, they are suffering from all these vices. So what is that you have to do? Not the law. You have to talk to them, find out what their personality is, and see that they understand. But they should understand what the problem is. And then some change of mind. counseling is most important. Today, even among diseases, in the days to come, mental health will be the number one. I was the judge who was implementing the Mental Health Act of 1987 in Karnataka. I also took it very lightly. When I went through it, first I found out I was a mental health patient. First you must understand you are a mental health patient. Then there is a remedy. And the result was, I stopped calling with my wife, with my children, with my colleagues, with my friends, and today I am enjoying it. This mediation is also one such thing. You get into litigation, then you must sit back, realize, and see what is the way forward. And today mediation has come very handy for those people who are sober, sane, understand life, understand the world. They can resolve this dispute amicably without going to the court at the earliest, and then see what next to be done in life. So in this context, my appeal to you is, in this profession, if you keep one wrong step, you will go in that. And by the time you realize it, it will be 20 years. But if you are careful enough and put your first step rightly, you will see the success in no time. So therefore, as youngsters, I am sure the present generations they are more intelligent than us, more enthusiastic, more energy. But my fear is, if it is not regulated properly, it may become a menace to society, and that's precisely what has happened. We have today like 11 or 13 national law schools, brilliant students, and today other institutions like this are in no way inferior to national law schools. So wherever I go, I see the youngsters. The fear I have is, if it is not regulated, they could become a menace to society. Because wrong things have been said. If you are a lawyer, you must do everything to see that your client succeeds. How is it possible? In my understanding, who is a good lawyer? A good lawyer is one who should not lose a good case, who should not win a bad case. If you are intelligent, you will win a bad case, injustice is done. If you have lost a good case, injustice is done. After all, a case is decided on the basis of the material on record. Your role is to see whatever rights that person has, that assistance is given to you. Not to make, earlier they used to say, a lawyer will make a black dog into a white dog. If you do that, injustice is done. So these concepts should go away. And that's why I've been before you and telling you, the youngsters, please don't be carried away by these things which they have been said for centuries. It doesn't help us. It will ruin you and ruin the society. So in that context, when we look at the mediation, how is it different from an adjudicatory process in court or an arbitration, which is much thought of in the country? In fact, this entire Arbitration Act, you find this enactment is passed based on that Arbitration Act itself. I was just comparing these sections. The same language is used, good. But the difference between mediation and arbitration you must have. No. And once that you know, it will be easier. Now in this background, let me point out to you the salient features of this mediation, which you must have in mind. Then only you will be able to appreciate this act. In this act, they have defined certain words. One, this was not there earlier. Till the act, we were using the words very loosely. According to me, this is the meaning, according to somebody, something else is the meaning. Today, there is an enactment. These words are defined. And as you know, while interpreting statutes, if the statute defines a particular word, you must give that meaning at all, nothing else. Now, One such word which you have to bear in mind is the definition of mediation. Therefore, I am happy. That's why I am coming here, because the word mediation itself was interpreted in a wonderful fashion. Now the word mediation has been done. According to me, this is the correct interpretation. Correct words are used. Mediation includes a process. It's a process. Whereby parties attempt to reach an amicable settlement of the dispute. Mediation is a process whereby parties are settling the matter. Then what is your role? With the assistance of a third person. So basically, parties have to sit together, talk, settle the dispute. You are only a facilitator. You are only assisting them. And that third person who assists in the settlement of dispute with the parties is called the mediator. Ignorance of mediator. Because when we started the mediation center, trained few batches, I used to sit in the mediation process to know how my mediator or someone who I trained is conducting. That's why I said it is not for ASS, not your problem. Young blood, intelligence, arrogance, it's all common qualities. I am not finding fault with you. So when you are asked to sit there and they say, "You think I am a judge?" That poor innocent litigants, they also think you are a judge. Whole atmosphere is gone. Nobody knew what their role is. Now the word mediation says it is a settlement between the parties in which you assist. Your role is only to assist the parties of settling the dispute. Now, you will find in the Act, when we started it was only a mediation. In the 20 years we have seen how it could be done. Today you have what is called as pre-litigation mediation. Even before the matter goes to court, pre-litigation. This was incorporated in the Commercial Courts Act. Even in the absence of an agreement with the parties to go for mediation, the statute compelled the parties, try your luck before mediation. If it fails, come to the court. In cases where no interlocutory orders are required, the Commercial Courts Act said parties must attempt at pre-litigation. Only on their failure you come here. The time spent in pre-litigation was exempted from limitation. Now that provision is deleted and then is brought into the mediation. Court annexed mediation. Court annexed mediation is the matter is before the court, section 89. If the court feels there is a chance of settlement between the parties, refer the matter parties to the mediation. So if court is keeping the control, it's called court annexed mediation. Institutional mediations. Now under this act, institutions have been created. You need not go to court. You can approach that institution. They have a list of mediators. They will appoint at your request the mediators and the process goes on. It's called institutional mediation. International mediation. The same words used in the international arbitration is taken into international mediation. If one of the parties to the agreement is a foreign country, it's called international mediation. Now they have added online mediation. Probably this is very helpful as far as today you can't live without Amazon, Flipkart, Swiggy. So any dispute in that probably could be dealt with by this online mediation. And they have also introduced what is known as community mediation. Take for example what's happening in Manipur. There are two communities fighting each other. Now the Act provides those community leaders can sit together and sort out the problem affecting the community itself. A great step according to me, provided it is implemented in the right spirit. And then the mediation. That is, you need forget about all these things. You appoint a mediator of your choice and go on with the mediation. So, based on our experience in the last 20 years under Section 89, today we have a comprehensive legislation providing for all these types of mediation. And if it is implemented in letter spirit with a proper understanding, it makes a lot of difference to the Indian judicial system. Now, we saw what is mediation. Who is a mediator? People think mediator is a broker in the land deals. You will quote one price to him and another for him. There is difference he will take. So that's the concept of mediators. No, it is defined. Mediator means a person who is appointed to be a mediator by the parties. First option is given to the parties. Both arbitration and mediation can succeed only if the parties choose the mediator and the arbitrator. The difference is, when you go to a court, you file a case. In Bangalore City Civil Court, there are 80 judges. The principal judge is given the authority to allot it. You will say go to 17 courts, you will say go to 19 courts, and you are finished in 19 courts. If that judge is an idiot, he is lazy, he doesn't understand, your fate is sealed. Or if he is biased, he is corrupt, your fate is sealed. Therefore, both arbitration and mediation says, we will give you the right to appoint a judge, appoint a mediator. Now, as students have seen Supreme Court judgments coming heavily on what is called as bench hunting. Judgment is all right. Why do advocates hunt a bench? Please tell me. What is the cause? When they know this fellow will not give me justice. They know this judge is inclined to do this. A judge is supposed to be neutral. Only when he is not neutral, a lawyer has to protect the interest of the client. And you call it as bench hunting, and then you come down heavily on them. This is also bad, that is also bad. Therefore, the essence or success of arbitration and mediation rests. They are giving you the right. Don't depend upon third persons. Don't appear before a stranger. You know in whom you have got confidence. You choose an arbitrator. You choose a mediator. What more do you want? Parties is given the right to appoint a mediator and a judge. That is possible only in mediation and arbitration, provided you exercise it properly. When you are also appointing, you appoint a person thinking that he is going to help me, then the process is gone. By the parties or by a mediation service provider. Now that is what has been defined into the Act. To undertake mediation and includes a person registered as mediation with the council. Mediation council is also a part of the Act. So they have said where more than one mediator is appointed, both of them put together is called a mediator. So today you know what is mediation and what is a mediator. This itself was not clear before this, and we had trouble there. Now mediation service provider is defined. You can look into the text. And then they have also defined what is called court annexed mediation, institutional mediation. Most important thing is this. This is where mediation has an edge over other alternative dispute resolution mechanisms. What is that? When litigation happens between two persons, is it really the two persons who are involved in that? A host of people will be here. A host of people will be here. They had no place at all in this adjudicatory process. They can come as a witness, that's all. They can go and instruct the lawyer. Between the judge and them, they had no role. Now that is recognized in the mediation, and they have defined what is known as participants. Section 3R defines the word participants. What do you mean by that? Participant means persons other than the parties who participate in the mediation and includes, this is important, advisors, advocates, consultants, and any taken experts and observers. So 5 categories of persons are recognized under the Act as participants. All of them can participate in the mediation process. That's where this mediation is arranged over other adjudicating processes. Now in reality, he may be a managing director of a company. It may worth about 10 crores, 100 crores. He is putting his signature on the dotted lines. When a litigation comes, he does not know. And you try to educate him, train him. He doesn't get it. He knows only how to make money. All this is useless for him, waste of time. If he is put in the witness box, I have seen sometimes, where was this, who prepared this affidavit? I don't know. It is his affidavit. He says, I don't know. Correct. Some advocate has prepared the affidavit, he does not know. Where was it notarized? In that chambers. Okay, in these chambers, because they paid money to the notary and brought it. See, this is the level of our society. Therefore, this act says, yes, recognize all that. When parties are sitting, they can have the assistance of all these persons. You want an advocate? Have an advocate. You want an advisor? You have an advisor. You want a chartered accountant? You have a chartered accountant. Any person who is able to assist him could be a participant. And with their assistance, the parties can resolve the dispute. Many times, party does not know what the case is. The person who instructs the lawyer is totally different from the party. Especially in rural India, that fellow does not know. There will be one fellow, very intelligent fellow in that village. Every morning, somebody will pick him up in the bus, now in a car, get him a nice breakfast. Then they go to the lawyer's office. Then he will instruct. The party does not know where the court is. This fellow has to take, he has to be taken care of. Civil Procedure Code provides for it. 1908 itself it has recognized it. Today, in mediation, we are recognizing it and giving an opportunity to all these persons. The reason is to have a settlement. They know the better. If they can sit together, on both sides advocates, on both sides technical people, on both sides chartered accountants, nobody can fool anybody. So therefore, this is a better process than other processes for settlement. If the intention is to settle the matter, not otherwise. Now who is a party? Party is a party to a mediation agreement or mediation proceeding whose agreement or consent is necessary to resolve the dispute and include their successors. So therefore, in a mediation, now let me tell you, especially when you are dealing with the matrimonial matters, both are youngsters, young, they have their own egos. Their problem is not that. The problem is in the house. Mother-in-law is a problem, father-in-law is a problem, brother-in-law is a problem, their cook is a problem. What will a lawyer do sitting in the, I look at this girl, why? What is that I am going to decide? I will never know what the problem at all. And the pleadings are drafted by advocates, keeping in mind the latest Supreme Court judgment. They have looked ready to some facts, so they bring in all those facts. We will never be able to know what the truth is. So therefore, no pleadings. Keep the parties together in a room. Let them shout at each other in the beginning. Because you are sitting there, both are safe. That is the assistance. Allow them to shout and then you will cool down. For that you must have experience. You also, if you also start shouting, then the end of it. That's why I said, your young blood may not be suitable for mediation. You will also become a party. You will also shout. You should have patience. Allow them. Let me tell you, as a mediation, as a mental health judge, I was also shouting. If some lawyer says, I was also shouting. Because he says something, I will also shout. Yet, after understanding this mental health, then I said, if anybody is shouting, is something wrong with me. So therefore, when somebody started shouting, I stopped shouting and I was enjoying. Also shout. Allow them to shout for 10 minutes. Then it, probably you have seen in roads, one dog will be on this compound. It will be barking. Another dog will be barking from it. They do nothing, only barking. After 10 minutes, everything is same thing. Atmosphere is in force also. So what the judges expected to do? So I said, keep quiet. See that they don't use force. Except that, do it. 10 minutes, that's all. Their patience is only 10 minutes. Then they will come down. Then they will also regret, I'm sorry, my lord, I made this. All right. Now you have said sorry, be all right here afterwards. Same thing in the mediation. When you are in a room, it's not a court hall, free for all. You will see the language, the best of the language you will see. You will not know the meaning of those words. So allow them. That's why they said, participate, allow the participants. And you will come to know the truth. I go on telling my experience as a judge, it was shocking, especially on matrimonial side. Especially when on matrimonial side, when advocates start routing, I used to say, I was sitting in Dharwad, in one case, I said, both the lawyers, all of you, all go to demands here, there is demands. First let a psychiatrist test both the advocates. I was proved to be right. The lawyer apologized to me at the end of the day. Yes sir, you were right, you were wrong. And we settled the matter. That's right. This experience, where will you get? You are very brilliant, your language is good, well educated, well dressed. That is different from experience. One matter I was handling, even though the mediation was not there, I applied. I will tell you how it was successful. He has married a girl, he has a daughter, that girl is 9 years old. Then dispute arose. I asked him, what is the problem? He said, dissolve the marriage on the ground of fraud. One of the ground of dissolution of marriage is fraud. What is the fraud? She told me that she is a graduate. She was not a graduate. She was not a graduate. After marriage, he completed the graduation. He completed B.Ed. He was working as a teacher. Now the argument for me is, on the day marriage took place, she had told me night and made me mad. What is the inference I should draw? Something wrong with this woman. So therefore I sent all the doctors, the lawyers to the... And at the end of the day, the lawyer who was shouting at me said, give me another 24 hours arrest. I said, yes. The next day he said, I will visit drawing the police. Wait, what happened? You are right, sir. I heard from my ears what my client's father was speaking. You are the root cause. They wanted to live happily. Okay? Father-in-law was coming. How do you come to know this in a court of law? Please tell me. If you know the problem, you can solve it. When you don't know the problem at all, how are you going to solve it? That's where this mediation has an edge. Only thing is you must have patience, you must have experience, and attempt should be to settle the dispute. Not to fight for with people. As I told you, if they are young, hard boiled. If they are intelligent, still worse. And there are some idiots. You look into the Hindu Marriage Act. One of the grounds for marriage is he is suffering from incurably of one's own mind. Right? In all the enactments, including the Contract Act, who is competent to contract? He should be 18 years old. He should be of sound mind. What are the mental health acts? This Marriage Act says incurably of unsound mind. That means if you are of unsound mind, no problem. Marriage is a success. That's not a ground for divorce. And if you ask me from my experience, if both are intelligent, as youngsters, please hear it, when you are selecting your partner, if both of you are intelligent, marriage is a failure. Marriage is a failure. So if one of them is of unsound mind, wonderful marriage, successful marriage. Of course, none of you have experience. I have some experience. Now today, whatever my wife says, I agree. Whatever my daughter says, I agree. I am the happiest man. Hitherto I was simply arguing, it was never ending. I go out in anger and they will do something in anger. And everything is that we are not able to enjoy it. Today, every minute is a fun for me. As youngsters have to If both of you are brilliant, intelligent, chances of marriage being successful is very, very less. If one of them is little, then it is a successful marriage which will last for 50, 60 years. So anyhow, the mediation, I am talking about the mediation. This is all mediation taught me all this. When you are mediating, because you know the law, you have some experience. Just observe these fellows. Then you will understand who is speaking the truth, who is not speaking the truth, who is the cause for trouble. And then you have to assist them in settling the dispute. Many disputes are not settled because of the lawyers. No, this is what 1947 Allahabad says. Where is what is we are in 2023. We are not following Supreme Court judgment itself. You can't talk to that lawyer. He is a brilliant lawyer. Justice Mahmood case is a great judge. In 1947 in Allahabad, he has said something. So you will have in 47 Allahabad, 67 Gujarat, for 24 Nagpur. Right, you come to 2023, society has moved. He may be 100% right. That will not help you in settling the dispute. So all that, no decisions are required here. You must know the law. You have to tell the client this is the law. There you have a role. That is the assistance. I will direct you the process. You can't be ignorant about the law. If you are ignorant of the law, you will not be a successful mediator. You must be, I would say, mediation requires super specialty advocates. Today we have super specialty doctors. He should be a super specialty advocate. He must know every branch of law and correctly. That is more important. And then he must be able to apply it. Then only you will be able to understand. You will be able to persuade his client. You are persuading the judge. Here you have to persuade your client to understand what the law is, where he stands. If the matter goes to court, where he stands. So therefore, in my understanding, as the law stands today, sorry for removing that word, you wanted to know what is the loophole. I am a judge. I want this law to grow. In our country, because we are ruled by Britishers, any law you find the loophole. Any law you don't obey because our blood is slavish. But 75 years are over. Today we are the rulers. We are making the law. Look at it in a positive manner. There cannot be any law which is 100% correct, which is applicable to everybody. As days pass by, you can amend it. So therefore I said, what is the way forward? And I call it to be one of the best legislation I have come across. Only thing is, if you are able to understand it, then we can make this enactment a success, the society a peaceful society. Now, as in the Arbitration Act, nobody can be compelled to go for mediation. Any contract entered into with the parties, if they agree, in the event of a dispute, it will refer to mediation, as you are doing an arbitration clause. A similar clause is required in the agreement as far as mediation is concerned. Here I said the sections are identical. What the Arbitration Act has, similar provision has been, but they have made it very clear. It must be in writing. And of course, some explanations are given how, even though it is not in writing, but it is writing in some other fashion, it could be. So that's a secondary matter. All of you are aware of the Arbitration Act. Similarly, here also a provision is made for an arbitration agreement. Maybe a separate agreement, or it may be a clause in an agreement itself. In our country, we have that Lok Adalat Act. Today, Lok Adalat is a big fraud, let me tell you. Sorry, sir, you are also aware. Now tell me, in your Lok Adalat, I see newspaper. This year in Lok Adalat, 8.5 crores cases are decided. Fine. If 8.5 crores are cases, the total number of cases pending in the court throughout the country is not even 4 crores. Then all the courts could have been closed. One case has not moved. What is this 8.5 crores of cases you are doing? It's a fraud on public entry. You create cases, you dispose of cases, you conduct wonderful function, then you go on giving only in motor vehicle cases, to some land acquisition cases. You have seen this local. Otherwise, traffic violation. When you want to conduct a A local adalat, 15 days back they tell the police about. So for 15 days you will book all these traffic cases and give it to you for disposal. Is it the way local? It's the most abused provision of law in local. And who are parties to it? Starting from Chief Justice, all judges. Is it not a fraud on the public? How much money is wasted on it? So therefore now, probably learning from that, in this section there is one provision. What is the provision? Section 6. Dispute or matters not fit for mediation. One is the fraud. Another is, what are the cases which are decided in Lok Adalat? They can never be decided in a civil court, except only frauds. Fraudulent agreements are put to seal. Is it the purpose of Lok Adalat? So taking a cue from that, now we have section 6 in the Mediation Act. We say dispute or matters not fit for mediation. So don't think of having mediation in these cases. Total bar, total prohibition. A mediation under this act shall not be conducted for resolution of any dispute or matter contained in the indicative list under the first schedule. So we have a first schedule. Disputes or matters not fit for mediation. Disputes which by virtue of any law for the time being in force may not be submitted for mediation. Wherever a court decree is required, by mediation you can't do it. Dispute relating to claims against minors, DTs, persons with intellectual disabilities, under paragraph 2 of the schedule, and person with disability having high support needs as defined in clause 2 of Rights of Persons with Disabilities Act. Persons with mental illness as defined in clause S of subsection 1 of section 2 of the Mental Health Care Act of 2017. Persons of unsound mind in relation to whom proceedings are to be conducted under order 32 of the Code of Civil Procedure, and suits for declaration of title against the government, declaration having effect of right in rent. Why was they did it? Is it because of the experience of your local? But I had to keep few judges, we removed the judges. A suit is filed for declaration that the plaintiff has perfected his title by adverse possession. What is the land? 20 acres of forest land. Who is the defendant? Forest official. Not the forest official. It's a declaration against a person. Land is a forest land. Government is not made a party. Some fellow is made a party. That fellow files a caveat. Even for a suit is filed. What is a caveat? They are going to file a suit and get an interim order against me. It will work. He files a caveat. This fellow files a suit. Because the caveat is there, he takes notice. Everything happens in 24 hours. Next day, compromise petition filed. Or matter is taken to Lok Adalat. Settled. What is settlement? A declaration that the 20 acres of land he has acquired title adverse possession. If the very judge has looked into the panis, it would have shown it is a government land. Given opportunity to Indians, they don't want to go in the right road. They always want to go. It's a last meant for facilitating peaceful life and see how far. Therefore they said, suits for declaration of title against government. They said no mediation. Otherwise, both of you will sit here and say Vidhan Sabha is mine and you say all right, take it. You need not go to court at all. Then on that basis you will file a suit. In that mediation settlement is property as part of my share, which is Vidhan Sabha. So to avoid that, they have said, what are the disputes which are not fit for mediation? Disputes involving prosecution of criminal offences, that you can't settle among yourself. Complaints or proceedings initiated before any statutory authority or body in relation to registration, discipline, misconduct of any practitioners, Bar Council of India will take care of it, you can't do it. or other registered professionals such as legal practitioner, medical practitioner, dentist, architect, chartered accountant, or in relation to any other profession of whatever description which is regulated under any law of the time begin force. That is kept out of mediation. Dispute which has an effect on rights of a third party who are not a party to the mediation proceedings, except only in matrimonial disputes where the interest of the child is involved. Any proceeding in relation to any subject matter falling within any enactment or which the tribunal constitutes the National Green Tribunal Act. So all national subject matter National Green Tribunal is taken away from courts, is also taken away from mediation. Any dispute relating to levy, collection, penalties or offences in relation to any direct or indirect tax or refunds enacted by any state legislature or the parliament. So law is, taxation is taken out. Competition Act, proceedings before the Director General, proceedings before the Telecom Regulatory Authority of India are all taken away from this. Proceedings before the appropriate commissions of the Appellate Tribunal of Electricity and Electricity Act, Petroleum, Natural Gas, Security Exchange Board, land acquisition and determination of compensation under land acquisition laws or any provision of law providing for land acquisition. Any other subject matter of dispute which may be notified in this law. So therefore, this act specifically says what are the matters which cannot be the subject matter of mediation. According to me, the experience they have gained all these years, they have made it sure that though they want mediation to succeed, it should not be misused, abused. Now the next question would be appointment of mediator. I said, you have a right, assuming you don't agree. Normally they don't agree. That's what I tell even in the case of arbitration. Law has given you a right to choose an arbitrator. Choose an arbitrator in whom you have confidence, who is honest, who is competent. You say, no, all right, court decides. This is according to me, a greatest disservice a lawyer can do to a client. He comes to you for advice. You choose a judge. No, they'll not the court decide. I was appointing arbitrators for more than 10 years. They used to accuse me. He is appointing only judges of his choice. The truth was, I had a list of 64 High Court judges, about 64 district judges. After coming to the conclusion, an arbiter appointed, I used to give an opportunity. Tell me whom you want. I could have said, tell me whom you want. More than 5 judges named, and nobody spoke. Therefore I appointed. The accusation against me was, I am appointing only these 5 judges. Today, they are appointing judges on rotation basis. Take it from me, in course of time it will fail. A mediator is a lawyer, is a judge, an arbiter. The whole bar of the society has seen how he has conducted himself when he was sitting in the office. That his horoscope is with you. After retirement, you have a choice to avoid such people. See the Arbitration Act. Everybody was pouncing on me. What is the ground of setting aside an arbitration award? Arbitrator has conducted himself as such as corrupt way. Can you ever think of a judge being corrupt? Can you ever think of an arbitrator being... No, the law recognizes it and it is a ground for setting aside. Same thing is repeated here. You appoint an arbitrator, with his assistance, an agreement is entered into. Within 90 days after the receipt of the agreement, you can challenge that award on the ground of fraud, on the ground of corruption. Corruption of whom? Not the corrupted parties. They are mediator. So we have to accept hard realities in life. Though we are all educated, enlightened, intelligent, we are not free from these. That is the bane of the Indian judicial system. So therefore, they have given you an opportunity to appoint an arbitrator, please see, unless otherwise agreed upon by the parties. That's the opening word. Parties have given the full discretion to appoint a mediator. Choose a mediator of your choice, a man with integrity, a man with capacity, a man with some record. If you don't do it, a person, proceed, of any nationality may be appointed as a mediator. You can appoint a Punjabi also, or a Japanese also, or a Kenyan also. That's all the Act says. Please see the extent to which it has gone. So therefore, then we have the mediation provider, institutions, they will get the opportunity to appoint arbitrators. My sincere appeal to all of you, when you get an opportunity to appoint a mediator, please exercise that right. Don't allow it to these institutions to do it. Don't fight on the ground who should be the arbitrator or the mediator. Of course, if you don't agree that the institutions are there, you have to approach them. Within 7 days, they have to appoint the mediators. And Act also speaks about termination of the mediator. Bona fide, you appointed a mediator. That mediator after appointment has to tell you whether there is any conflict of interest. The Act says he shall tell the parties in writing if he has any conflict of interest. This is the problem. What do you say? Parties may say, don't worry, you go ahead. For example, I had this occasion. My salary was credited to a bank which is the High Court itself, extension counter. A dispute came before. I have not gone to the bank. I don't know who the fellows are. I said, my bank. Only salary is credited, I am withdrawing this. Tell the parties. They said, no, you continue. In fact, I did not want to continue. I threw it away. Otherwise, on some day, we get bad names. Therefore, even if an appointment of a mediator is made, if he says he has conflict of interest, you have the right to say, thank you, get out, or you can allow him. Or in the course of the proceedings, it comes to your knowledge that there is something fishy, you can terminate the proceedings. So such a right is given to you. That right you must exercise before agreement is already, not after the agreement. And then you could replace that mediator with another mediator. Thus, there are the provisions here. Now, in all these cases, the question is, where should the mediation take place? Same in the case of arbitration. Regular court, I understand. So, the law has been consistent both in the case of mediation and also in the case of arbitration. If this dispute, you wanted to file a suit, you wanted to go to court, which is the court which has jurisdiction? That court will have jurisdiction to deal with mediation. The only difference is, when you are mediating, if the day of mediation in Bangalore, it is hot, and if the parties can afford to, you can say, come on, we'll go to Ooty. We'll have mediation process in Ooty, in a better atmosphere. Though mediation happens there, the court at Bangalore will have jurisdiction if it comes to challenging that agreement of mediation. So that's how in arbitration also said you can conduct the arbitration proceedings anywhere. But the court which will have the jurisdiction to entertain a challenge to that mediation is the court where the properties are situated, where the contract was entered into, where the contract was broken. Same provisions are incorporated into the mediation. Now, how do you start the mediation? If there is an agreement, you issue a notice. That notice, the moment it is served on him, the mediation starts. That's the starting point of mediation. Because there is a time limit. Today, within 4 months, please understand, it's a beautiful legislation. Within 4 months, the mediation should be over. The maximum time which could be extended is for another 2 months, that is 6 months. If within 6 months the mediation agreement is not reached, the mediation comes to an end. By operation of law, nothing more need be done. Therefore, today's stress is on completing, because the mediation also takes 2 years. What is the use? 4 months plus 2 months. If in 6 months it is not done, by operation of law, mediation comes to an end. Question of extending the time will not arise. In the arbitration, there is a provision for extension of time. In mediation, the extension is only for 2 months, and within 6 months it should be over. If you have not chosen to appoint a mediator, you approach the institution. The moment the institution appoints a mediator and the mediator gives his consent, that is the starting point for mediation. So therefore, date of appointment of a mediator, date on which the consent of the mediator is given, or the date on which you issue a notice and notice is served on the other side, That is the starting point of mediation. So law is very clear. When does it start? It is because within 6 months it should be over. Now the most important thing for those who want to become mediators. Here, as I said, the real principles of mediation are now found in section 15 and 16 and 17 of the mediation. This is according to be the heart of mediation. The mediation process shall be conducted in the manner as may be specified. They are yet to specify, but some indications are given. The mediator shall assist the party in an independent, neutral, and impartial manner. Independent, neutral, and impartial. These are the qualities which are required to be a judge also. So if you want to be a mediator, you can't say, I will be different from a judge. No. That's why I said, whether you are an advocate, you are a judge, or a mediator, these principles are not negotiable. What are they? You must be independent. You should not be cowed down. You should not be influenced by any person. You should be neutral. No question of preferring one party over the other. And impartial. This is the hallmark of a judicial system. Now mediation is a part of the judicial system. The person who is doing mediation is a different person, not a judge. Maybe a judge also. But whether it is a judge, a lawyer, a student, or whoever it may be, these qualities, if it is not there, mediation will not be. The mediator shall at all times be guided with the principles of objectivity. So therefore, you should not bring in your personal matters. In my house, it happened like this. Have that experience, but don't bring in here. How you dealt with your wife, you can't deal with that lady. That is no. Experience is all right, but you must objectivity and fairness and protect the volunteerness, confidentiality, and self-determination of the parties. This is important. You must have the quality of an independent, neutral, and impartial manner, and you must allow, protect the volunteerness. The parties voluntarily should agree. No compulsion. Confidentiality. Nobody knows, nobody should know what's happening. And self-determination. Party should take the decision, not the arbitrator, not the mediator. That's the difference between mediation and the other process. The person to take a decision is the party and not the mediator. In the case of an arbitration, arbitrator takes the decision. In the case of a court, judge takes the decision. In the case of a mediation, party should take the decision. The mediator has no role to play. And this is, they are yet to prescribe standards for professional and ethical conduct as may be specified. Still they have not done it, and I am sure whatever quality which is required to be a judge should be required for a mediator. Now, what is the process? The mediation process may include the mediator taking such measures as may be considered appropriate. There he has a freedom. Taking into account the circum of the case, that is very important. Circumstance of the case varies from case to case. There are no two cases which are alike. The first thing is you must look into this circum of the case means circumstances of the parties, including meeting with the parties or participants. Party also will be there, his advisor will be. Sometimes you cannot talk to them, both of them together. Either you take the party separately and talk to them, you take the participants separately and you talk to them, it is permitted. Jointly or separately, as frequently as deemed fit by the mediator. Both in order to convene the mediation and during the mediation for the orderly and timely conduct of the process and to maintain its integrity. So here there is a difference between arbitration, adjudication in a court and mediation. In court or in arbitration, everything should be done openly. transparency is the test. You cannot ask the party to come to your chambers and you can't talk. You can't ask him to come to, no. Then you are suspect. Just opposite is the mediation. When we are talking, some negotiations are going on. He sticks to some stand. He sticks to some stand. You can't express your opinion. You should not. Or the lawyer on the side takes a stand. As I told you, 65 Allahabad. God does not know, subsequently it is overruled. So then, what the mediation process gives the liberty to the mediator is to take the one party completely to the chambers. Have a discussion. This is what you are saying. Do you know what the law is? If the lawyer says, no, this is the law, then have a meeting with the party. Look, this is what he is saying. See the latest judgment of Supreme Court. If you go by that advice, you will be ruined. To go to court, this is the law. The case will be decided according to this law. You can't tell him, the lawyer, that you don't know the law. He will start coaching him. Then you advise the client to withdraw from the argument, mediation. So you have to be, that's why I said you must be up to date with law. You must be thorough with the law. Apart from your personal experience, knowledge of men and matters, other extraneous circumstances to your knowledge, you must be up to date with the law. You must know the law more than a judge knows the law, because he is advising. But at the same time, you can't force him. You can tell him, this is what your lawyer is saying. Probably he has not looked into the judgment. You can't blame the lawyer also, then this fellow will be imposed on you. So it's a very delicate, that's why I said it's a super speciality. The expectations from such person is so high. You must be so much skilled. So how do you convey to the party or to the advocate they are wrong, and if they continue this, and if the ultimately matter goes to court, you will be the loser? Which you can do it. In arbitration I can't do it. Sometimes I am hearing an argument. You will be talking nonsense, lawyer. He is paid for it. The client is sitting in the bank. Just to please him, he will be talking something. I can't say, to please your client, you are saying. So you have to keep quiet and then pass an order. Here that is not so, there is no order. Parties must agree. When will the parties agree? If any person says 100% case, he will never agree to anything else. In an arbitration, take it from me, both the parties will not get what they want 100%. There must be some give and take. That's why they say both are winners. They don't say both are losers. Both are winners. Win-win situation. You must be prepared to give up something. He must be prepared to give up something. Then only there can be a settlement. You know this is your case. He knows that this is his case. You don't know the strength of your case. Your lawyer says you have an excellent case. If not here, I will succeed in Supreme Court. That means after 40 years. This is the advice given. If you want a settlement today, so you must know on what I will not agree. What I will sacrifice, I will not. Therefore, you must. That's the role of a mediator. In the opening session, you should be able to tell the parties, look, you have taken a particular stand, which is not acceptable. He has taken a particular stand, it is not acceptable. Then where is the question of meeting the point? So you must be prepared to give up something. You also must give up something. Then there is a meeting point. And they will come to a particular stage. Still there is a gap. That's where the mediator's role comes into play. How do you persuade the party to come a little forward? How do you persuade this party to come forward? It's a skill. It is not citing Supreme Court judgment. It is not citing American court judgment. You understand the law, but you must persuade the party. So therefore, meeting with the parties or participants, jointly or separately, as frequently as deemed fit by the mediator, both in order to convene the mediation and during the mediation for the orderly and timely conduct of the process to maintain its integrity. No, I don't know why they have said it. Mediators shall not be bound by the Code of Civil Procedure or the Indian Evidence Act 1872. Without exception, everybody is blaming those two enactments. And my understanding is, both of them, anybody who is talking about that, they don't know the law. They are the most beautifully crafted legislations, which have withstood the test of time. You are not able to touch anything. But they say, you need not be. To become a mediator, only when you know solid what the Evidence Act and the procedure of law, you can be a successful mediator. But here the question of applying will not arise. There is no question of proof. There is no question of production of documents. There is no question of Evidence Act. Knowledge is there, but anyhow, in all the legislations you will see this. Evidence Act is not applicable and Civil Procedure Code is not applicable. Now, this is about the mediation process. Then, role of a mediator is also defined. That's where I said this law makes a very good beginning. The mediator shall attempt to facilitate, mark these words, attempt to facilitate voluntary resolution, no force, voluntary resolution of the dispute by the parties. What is your attempt? You must see that the parties agree to something voluntarily, not by force, and communicate the view of each party to the other. So I hear him. So when we are talking together, you will say, sir, this is the maximum, this is the minimum. So when you go communicate to him, you can't tell the minimum. You should also bargain. So for example, the recovery of money. He says, I am prepared to pay. I will be satisfied if he gives me 5 crores. I am happy. Claim is about 8 crores or 9 crores. You can't go and tell them give 5 crores. He will say I will give 3 crores. Only when you do it. So keep the 5 crores. Then try to negotiate. Sometimes it so happens, parties out of desperation, though they have a good case, they are prepared to give up. That's where the role of a mediator. You should prevent it. Justice should be there. When this man says 5 crores, go on telling him, it doesn't help you. So you know, as a lawyer or as a judge, where the justice lies. So though he gives you that instruction, you are not expected to communicate the whole thing. You sit with him and tell him, I will get you 7.5 lakhs. And he will say, no, 7, 630. Because he has said 5. So ultimately at this was 6. You can't have that 1 crore for yourself. Please. That is real estate brokerage. That's where the integrity, character of a mediator comes in. Telling both of them some figure and in the middle taking some figure is not mediation. And unfortunately that's what they are doing. That gives a very bad name to mediation. Communicate the view of each party to the other to the extent agreed by them. Assist them in identifying issues. Given the opportunity, they will be talking only nonsense. But you have to tell them, that is not the point in issue. Come to the point. You don't go on saying what your mother-in-law did, what your friend did, your neighbor did. Come to this. What he did, you please tell me. Advancing better understanding. Many times they may not be able to have a clear ideas. So you must make them understand what the problem is and then make them understand it. Clarifying priorities. Exploring areas of settlement and generating options. If they don't have a solution, you can generate. You can't force. See whether it is possible. To do this, how many years of experience a mediator requires? You are not dealing with machines, you are dealing with human beings. Law is all right, section is all right, Supreme Court judgment is all right. It is a human experience. That's why I said no offense to the youngsters. You come with enthusiasm, but this is what is expected. If you don't have this qualification, ask yourself, can I be a mediator? So this is now, law is enacted specifying these conditions. Now there cannot be any variation from this. In an attempt to resolve the dispute expeditiously, emphasizing that it is the responsibility of the parties to take decision regarding their claim. The decision ultimately is that of the party and not the mediator. And this is important. The party shall be informed expressly by the mediator that he only facilitates in arriving at a decision to resolve the dispute and that he shall not impose any settlement, nor give any assurance that the mediation may result in a settlement. Now, in this background, let us see what Lord Krishna did. Was he a mediator? He was representing Pandavas. He went to Duryodhana and said, "Give me something, I'll make them agree." That is not mediation. What Hanuman did? Send back Sita. Then there is no dispute at all. And then you said Panchayati, Panchas, which 5 people were deciding in the village. What they were doing, they were very big people. They helped the parties. They said this is to be done. If the party doesn't agree, he had it. That is not mediation. Decision is not by Panchas. Decision should be by the parties. That is mediation. You must only assist them. Make them understand the problem. If they can't make out, just generate some ideas, generate some options. But ultimately the decision is of the parties. That's why I said this concept is unknown to India. Krishna is not a mediator. Hanuman is not a mediator. Panchayatas are mediators. Yes, they had a big role to play, that's all right. But don't bring into mediation and spoil mediation. And the mediator should say, I am not going to decide it. The party should not say, the mediator is going to decide the case. No, you must make it very clear, I am not deciding it. I am not compelling you to agree to anything. I am not forcing any decision. You have to decide in my presence. That's all. So therefore, once after mediation, the parties agree, then the agreement could be written by you. They sign and you also authenticate it. Now provisions are made for registration. But if it is not possible to have a settlement, then mediation comes to an end. If it refers to you by authority, inform them that there is no mediation. And all this should be done within 6 months. Time is the essence. And beyond, because the section is very clear. I am glad that's how they have made it, so that nobody can play with this. They have said, how does the mediation come to an end? Please bear this in mind. No extension of time, no Mediation Act. Very good provision. By operation of law, it comes to an end. You can't sleep over the matter. Section 24 speaks about termination of mediation. 1. When a mediation settlement is erected, if the matter is referred to you by authority, inform them. D. On the expiry of time limit under section 8. 4 plus 2, 6 months. After 6 months, it comes to an end. There is nothing you can do. Of course, the Act is now provides for what you mean by confidentiality. And then, this is the most important. Mediation, sometimes people are afraid of coming to meeting, afraid of speaking also. There the lawyers have a role to play. Whatever happens in the mediation. So I was conducting a mediation between a big law firm and this. They said, no, I will not put it in right. I said, you are the biggest law firm in the country. Don't you know the law? No, sir. That's the Indian mentality. If I put something in writing, it will be an admission. Law makes it very clear. Anything done in this mediation is wiped out. You can't produce it before the court. Even if you produce it, the court should not look into it. That's not a piece of evidence. Emphatic. Law is very emphatic. An opportunity is given to parties to decide. Come out, speak the truth. By uttering falsehood, you can't settle the dispute. You speak out the truth. In the court, you read now. Here you must. And you have made some concession. You have made some admission. The matter did not end here. That can't be taken advantage of. Even the mediator cannot be summoned to say, this is what happened. No, mediator will not appear. Neither the mediator, nor the parties, nor the persons who assisted them in mediation, they can be compelled to come to the court as witness. Anything which is recorded, it may be in writing or it may be electronic, that can't be used as evidence in a matter goes to dispute. So such a foolproof system is brought in, giving an opportunity to the parties to decide among themselves the dispute and avoid this litigation. So therefore, correspondingly, the several enactments which dealt with mediation are also amended. Indian Contract is amended, Commercial Act is amended, Code of Civil Procedure is amended, then Legal Service Authorities Act is amended, Arbitration Conciliation Act is amended, then in fact the entire chapter regarding conciliation which was found in the Arbitration Act is now deleted. Then Micro, Small, Medium Enterprises Development Act is amended, Companies Act is amended, and Commercial Courts Act is also amended. So such an exhaustive enactment is passed, providing for mediation. And today, mediation is a part of Indian law. Now the question is, how do we make use of it? Blaming the judicial system is all right. Now, ADR mechanism has come. Your arbitration is also not working very well, of course. To some extent it is. Now, this option of mediation is there. Mediation can succeed only if the parties are honest. It is not there. Lawyers are honest. It is not there. To some extent, mediators are there, I think. But mediator by himself can't do anything because he has no role to play. It is the parties, their advisors, who should make up their mind to have a settlement, one way or the other, so that they can enjoy life. If litigation is the way they want to enjoy life, mediation is a failure. If they want to enjoy life in a real manner, mediation is a golden opportunity. They're all youngsters. There is a criticism. This mediation is affecting legal profession. What should happen to us? So I'm asking you, you are coming to legal profession to make a living out of somebody's misery. This is the argument. Bar counsel attacks it. So if you ask me what is your experience, I was also a lawyer. Now I was a judge. Now I am a retired man. Now my two daughters are also lawyers like you. Therefore, I have no conflict of interest. And let me tell you what you should do. In a litigation which takes about 10 years, what is the fee you are going to get? In the end of the day, you will be spending more money than you got as a litigation towards your petrol expenses, hotel expenses, your dress. And you will be wasting all your precious young age in the court corridors doing gossip. As opposed to that, let's look at the mediation. Even if you get 1/4 of that fees in mediation, that is your money. Now all of us are ready. The moment you enroll, you will get married. It is a life. You need time. Some lawyers, youngsters will be in the chambers till 1 o'clock, 2 o'clock. What will be doing, I don't know. No, we have work. Of course, my daughter is no exception. She comes at 1 o'clock. First daughter was coming at 11 o'clock. My sleep was spoiled. Now this girl I am not because somebody is escorting her, then I sleep. You come and sleep. They don't understand. I am telling you. Because I have a daughter of your age, I am telling you, you people don't understand what I am saying. In this profession, let me tell you, of course, if you are all coming from good families, money is no problem. When we started, I had only 2 pants and a chappal, and shoes. If there was a rain, there was a problem. So we had to work 24 hours. How many years? 15 years. Before we could have some money. By the time marriage is over, the children are over. By the time I saw some money, half the life is over. No time. That's why I said the profession in the beginning, there is only work. There is only work. After some time, some work and some money. Thereafter, only money, no work. Then you become a senior. Then you have only money, but nothing is there. Your youth is gone. Where will you go? You go to Sylvan land at that age? Somebody has to take you. That's what I'm telling you. You must know how to balance. You have a career of 50 years if you want to be a mediator or a lawyer or what. Enjoy life. Marriage is also a must. That's why I told you, 2 billion people marry. Marriage is the thing. So, young, energetic, intelligent, you have a wonderful opportunity. The legal profession was not so bright as it is today. Today everybody wants their children to come to the profession. I'm a first beginner. When I came to the profession, no lawyer wanted their children to be in the profession. Today it has totally different. So world is yours. But if you don't enjoy, and if you are wasting your time till 2 o'clock, whatever may be a constitutional matter, you saw the argument in 370, right? Is there any substitute? What a brilliant lawyers, brilliant time. Do they have any concern for the country? Money is given, somebody has paid you, you can go on. And those judges are also, they have no option. Otherwise you will be a Gallagher judge who is already made up his mind. To make up a mind, how much time is required? 15 days. These are all some of the, I would say, wrong things which has crept into the profession. Because you are all young, you are yet to be influenced by these matters. You have intelligence, think for yourself. Why have you come to this profession? Why have you come to this world? What is that you want to achieve? Is money thing everything? Is fame everything? As I said, after 60 I have money, but I can't go to Switzerland, I can't go to Ooty. What is the use? So when you want to go, at the age when you have to go to Ooty, please go. When you want to go to Switzerland, you go. Heavens are not going to fall. Your mediation will continue, arbitration will continue, courts will continue. But make sure the money you earn is worth it. People who earn money, just look into their lifestyle, how their homes are there. Then you will never think of it. In this profession, especially today, there's plenty of them, which was not there when I entered the profession. If that money is not coming in a right manner, you will become a candidate. Money will be there, you will not be able to enjoy it. And you want name that will not be there in your lifetime, then the life is a waste. So in those circumstances, I say the mediation is a wonderful concept which has now come into the legal profession, into the Indian system, where if you are able to prepare your clients properly, if you are prepared to advise them properly as lawyers, don't think of mediators, as lawyers. And if you are able to bring a settlement, he will remember you forever. The relation between a client and a lawyer is lifelong. Let me tell you, my clients used to come and ask me, sir, I have selected a boy for my girl, easy already. How am I now? I have neither seen the girl nor the boy, but he wants my consent. I want to have an operation. To which hospital I go? To which doctor I go? That is the wonderful relationship. So there between lawyers. Today, that relationship is gone. If that relationship is gone, this legal profession is nothing. If you are able to maintain that profession, you are the real heroes and heroines in life. Don't worry about this heroes and heroes of Hollywood or Bollywood. You will be the heroes. You will be the heroines, and you can enjoy life. Thank you.